Something is happening right now that could directly affect your Social Security check, and most people have absolutely no idea it's coming. The Supreme Court of the United States has just made a ruling, and the ripple effects of that decision could reach into your bank account, your Medicare coverage, and your retirement benefits faster than anyone expected. We're talking about 2026. That's not years away. That's right around the corner. And here's the thing. The government is not going to send you a letter. They're not going to call you. They're not going to knock on your door and say, "Hey, we just want to make sure you're aware of what's changing." No, that's not how this works. You have to find this information yourself, and that's exactly why you're here today. So stay with me, because in the next few minutes, I'm going to walk you through exactly what happened, what it means for you personally, and what you need to do right now to make sure your benefits are protected. Let's start at the beginning. For decades, federal agencies like the Social Security Administration, the IRS, and the Department of Health and Human Services have operated under something called the Chevron Doctrine. Now, I know that sounds like legal jargon, so let me break it down in plain English. The Chevron Doctrine basically said this: when a law passed by Congress is unclear or vague, the federal agency responsible for enforcing that law gets to decide what it means. So, if Social Security law was fuzzy on a certain point, the Social Security Administration could just fill in the blank however they saw fit, and courts had to go along with it, as long as the agency's interpretation seemed reasonable. For 40 years, this gave federal agencies enormous power. Power over your benefits, power over what you qualify for, power over how your money gets calculated, delayed, approved, or denied. But here's the problem. The Supreme Court just threw that out the window. In a landmark 6-3 decision, the Supreme Court overturned the Chevron Doctrine entirely. The case was called Loper Bright Enterprises versus Raimondo, and while it started as a case about fishing boats and federal regulations, what the court decided goes far, far beyond fishing. Legal experts across the country are now saying this could be one of the most consequential rulings in modern American history. So what does this mean in real terms? It means that from now on, when a law is unclear, it's not up to the federal agency to decide what it means. It's up to the courts. Federal judges, not bureaucrats inside the Social Security Administration, will now have the final say on how laws are interpreted. And this is where things get serious. Because right now, there are dozens of ongoing legal challenges to Social Security rules, Medicare policies, and federal benefit regulations. Cases that were previously dismissed or decided in the government's favor because of Chevron. Those cases can now be reopened. New cases can now be filed with a much better chance of winning. And the rules that were built on Chevron's foundation? Some of them may not hold up anymore. Think about that for a moment. Rules that have governed your benefits for years. Rules about who qualifies, how benefits are calculated, what Medicare covers, what gets approved and what gets denied, all of that is now potentially up for legal challenge. And the people challenging those rules are not all on your side. Some of them are advocacy groups who want to expand benefits for seniors. But others are corporations, insurance companies, and political interest groups who want to cut costs, and your benefits may be standing right in their way. Now, I want to be very clear about something. This does not mean your Social Security check is going to disappear overnight. Nobody is pulling the plug tomorrow morning. But what it does mean is that the legal landscape has shifted dramatically. The ground under your feet has moved. And the direction that things are likely to move in 2026 and beyond is something every single person collecting Social Security or Medicare needs to understand. Let me give you a real-world example of what this could look like. Right now, the Social Security Administration has rules about how they calculate your average indexed monthly earnings. That's the formula that determines how big your benefit check is. For years, the SSA has interpreted certain parts of that formula in specific ways, and those interpretations were protected under Chevron. Courts couldn't easily second-guess them. But now, without that protection, attorneys are already exploring challenges to those calculations. If courts start ruling differently on how those formulas are applied, some people could see their benefits adjusted, and not always in the direction you'd hope. Here's another area to watch closely: work history and disability determinations. The Social Security Disability Program, SSDI, has always been governed by strict agency rules about what conditions qualify, how severe a disability has to be, and what kind of work you're capable of doing. Disability denials happen all the time, and many people just give up. But under the old Chevron system, even when those denials seemed unfair, the courts often sided with the SSA because the agency had the authority to interpret the rules. That's changing now. And it cuts both ways. More denials may get successfully appealed, but it also means the rules governing what qualifies as a disability could be challenged by those who want to make the program stricter. This is why you cannot afford to be passive right now. And if you're on Medicare, listen carefully, because this affects you too. Medicare's coverage rules have long been interpreted by the Centers for Medicare and Medicaid Services, what they call CMS. They decide what's covered, what's not covered, what drugs are on the approved list, and what procedures require prior authorization. All of that has been backed up by the Chevron doctrine. The agency decides, and the courts defer. Not anymore. That means Medicare Advantage plans, prescription drug coverage under Part D, and coverage decisions for things like home health care and skilled nursing facilities are all now subject to new legal challenges. Some of those challenges could actually benefit seniors, but others could be used by insurance companies to argue that certain expensive treatments shouldn't be covered at all. Most people don't realize this, but insurance companies have teams of attorneys whose entire job is to find legal arguments that reduce the amount they have to pay out. And with Chevron gone, they now have a much stronger toolkit to work with. So, what should you be doing right now? I'll get to that in just a moment. But first, I want to talk about something that doesn't get nearly enough attention. There is a second major legal battle brewing that connects directly to this Supreme Court ruling. And it's about the Social Security funding formula itself. For years, Congress has known that the Social Security Trust Fund is facing a projected shortfall. The latest estimates suggest that by 2033 or 2034, if nothing changes, the trust fund could be depleted. At that point, benefits would automatically be cut by roughly 20% across the board unless Congress acts. Now, in the past, the SSA and Treasury Department have had a lot of flexibility in how they manage those funds, how they project future shortfalls, and how they communicate those risks to the public. A lot of that flexibility came from Chevron-style deference. The agencies could interpret the law in ways that gave them more room to maneuver. Without Chevron, those interpretations are now open to legal challenge. And this matters for you because it could affect the timeline and the urgency of congressional action. It could affect how the government presents Social Security's financial health to the public. And it could affect whether emergency measures, things like benefit adjustments, taxation changes, or eligibility modifications, get pushed through faster than expected. There are members of Congress right now who want to raise the retirement age. Others want to change how the cost of living adjustment, your COLA, is calculated. And still, others want to means test Social Security, which means if you have too many assets or too much income from other sources, your benefit could be reduced or eliminated entirely. These proposals have always existed. But the political and legal environment in 2026 is more unpredictable than it's been in decades, and the Supreme Court's ruling adds one more layer of uncertainty to an already complicated picture. Now, I want to take a second here, because if you found this information helpful so far, if this is the kind of content that you feel every senior in America should be watching, please take a moment right now to hit that like button and subscribe to this channel. Every time you do that, it helps us reach more people who need this information. people who might not know where to turn. Your click literally makes a difference to someone else who needs to hear this. So thank you. Genuinely. Now, let's talk about what this means practically and what steps you can take to protect yourself. The first thing you need to do is get your Social Security statement up to date and verify it is accurate. You can do this right now at ssa.gov by creating or logging into your My Social Security account. Look at your earnings history year by year. Look at your projected benefit amount at different retirement ages. If anything looks wrong, and errors do happen, you need to dispute it now before the legal landscape shifts any further. Mistakes in your earnings record can cost you thousands of dollars over the course of your retirement. And with agencies under increasing legal scrutiny, getting your documentation in order now is more important than ever. The second thing you should do is make sure you understand exactly which Medicare plan you're on and what it covers. With potential challenges to coverage rules on the horizon, knowing your current benefits inside and out is your first line of defense. If something changes and your plan suddenly denies a claim that was previously covered, you need to know that something changed. You can't catch a problem if you don't know what normal looks like. Third, if you are receiving Social Security disability insurance or supplemental security income and you've had a recent denial that you haven't appealed yet, you need to look into that appeal right now. The window to appeal is usually 60 days from the date of the denial notice. With the Chevron decision opening new legal avenues, disability attorneys across the country are taking a fresh look at cases that previously seemed like dead ends. Fourth, and this one is important, do not make any major financial decisions based on assumptions about your future Social Security benefit amount. Don't decide to retire early. Don't choose to delay benefits assuming they'll be higher later. Don't assume the COLA will stay the same. The next 2 to 3 years are going to bring significant changes to how benefits are calculated, administered, and potentially reduced or restructured. Get professional advice from a Social Security specialist or a financial planner who specifically works with retirees. Not a general financial advisor, someone who lives and breathes Social Security strategy. Fifth, stay connected to sources of information you can trust. I know that sounds obvious. But the amount of misinformation floating around about Social Security right now is staggering. People are sharing things on Facebook and in family group chats that are flat out wrong. People are making decisions about when to file, whether to work part-time, and how to handle spousal benefits based on advice that hasn't been accurate in years. The rules change. The law changes. And as we've just seen, even the legal framework that governs how the rules get made can change in a single Supreme Court decision. Here's something else most people don't think about until it's too late. The Social Security Administration has a backlog right now that is the worst it has been in decades. Wait times for hearings. Wait times for disability determinations. Wait times just to speak to someone on the phone. Offices have been understaffed, resources have been stretched thin, and if new legal challenges flood the system with more appeals, more contested cases, and more court involvement, that backlog is going to get worse before it gets better. If you have any kind of pending application, pending appeal, or unresolved issue with Social Security or Medicare, do not assume it will work itself out. Follow up. Be persistent. Document every interaction. Write down the name of every representative you speak to, the date and time of every call, and what was discussed. This documentation could be critical if something goes wrong and you need to prove what you were told. Now, I also want to address something that may be on your mind. You might be thinking, okay, this is all very concerning, but these are legal battles. These are things happening in courtrooms. What can actually change, and how fast? That's a fair question, and the honest answer is that some changes could happen quickly, and others will take years to work through the courts. But here's what history tells us. When a major Supreme Court ruling shifts the legal landscape, the most aggressive actors move first. The industries and interest groups that have the most to gain from reinterpreting the rules pour resources into legal challenges immediately. And by the time the average American realizes something has changed, the decision may already have been made. That is exactly what happened in the 1980s when major Social Security reforms were passed. Millions of people were caught off guard by benefit reductions and eligibility changes they never saw coming. It took years for many seniors to fully understand what had happened to their benefits. And by then, the window to plan around those changes had already closed. You have a window right now. Use it. Use. The political will to protect Social Security benefits has always depended on how loud and how organized seniors are. When seniors pay attention, when they vote, when they call their representatives, when they make their voices heard, politicians listen. But when seniors are confused, disengaged, or overwhelmed by information they don't understand, that silence gets filled by the people who want to cut costs and change the program. You being here, watching this, learning about what's happening, that matters. Knowledge is not just power. In this case, knowledge is protection. Let me bring this home for you. Imagine you're 67 years old. You retired 2 years ago. You planned everything around your Social Security benefit and your Medicare coverage. You've got a budget. You know what's coming in every month. And then one day you get a letter. Or worse, you notice your deposit is smaller. And you have no idea why. You call the SSA and wait on hold for an hour. You get transferred 3 times. Nobody can give you a straight answer. And you realize you don't actually understand how your benefit was calculated in the first place. You don't know your appeal rights. You don't know who to call or what to do next. That is a terrifying position to be in. And it is completely preventable. The people who come out of the next 2 years in the best shape are the ones who paid attention now. The ones who verified their records. The ones who talked to a professional. The ones who understood what was at stake before the changes arrived. Don't let this Supreme Court decision be something that happens to you. Make it something you were prepared for. The ruling has been made. The legal challenges are coming. The changes are being written right now in courtrooms and congressional offices across this country. And whether those changes help you or hurt you may depend entirely on how informed and how prepared you are going into 2026. So here's what I want you to do before you close this video. Go to ssa.gov and log into your account today. Review your earnings record. Check your estimated benefit. Write it down. Then look at your Medicare coverage and make sure you know what's covered. If you've had any recent issue with Social Security or Medicare that hasn't been resolved, put it on your list to follow up on this week. And then come back here, because we are going to keep covering every development in this story as it unfolds. Every new court case, every proposed change in Congress, every update that could affect your check, your coverage, or your future. You deserve to know what's happening. You earned these benefits. And you have every right to protect them. If this video helped you understand something important today, please like it, share it with someone you know who's on Social Security or Medicare, and make sure you're subscribed so you don't miss a single update. The next few years are going to move fast. Stay close, stay informed, and don't let anyone catch you off guard. This story is not over. In fact, it's just getting started.